And we'll call up the next group. Jim Pickle, I think that's how you pronounce it. Stuart McMullen, Jeremiah Newman, and Judy Powell. That's it. All right, Mr. Pickle, is that how you pronounce your name?
Yes, ma'am.
Just like it's spelled.
My name is Jim Pickle. I'm a constitutional and civil rights trial and appellate lawyer. I've been doing it for 30 years. I am the lawyer that was in the Jim Lewis case, whose story has been submitted to the panel, to the committee. First, I'd like to try, if I can, to bring a little clarity to this. Sitting there listening to the last panel, we kind of seem to be talking crossways with each other. The best interest of the child and fit parent are both, of course, doctrines or ideas that require some type of decision making. And the person we let make that decision is the court, if it's in contest. What Troxel says, U.S. Supreme Court 2000, it says this: we start with a presumption. No matter how you get to court, the judge starts with the presumption that the parent is a fit parent. Fit parenting is not proven. Fit parenting is presumed. The court instead must have evidence to overcome the presumption presented by CPS, the state, by another parent, by grandparent, by third-party neighbor. Somebody has to present evidence to the judge to overcome that presumption. This bill does two things. It codifies that presumption in statutory law, which is going to be very beneficial to judges. As I'm sure Madam Chairwoman would tell you, is that judges love statutory direction. They like that. The second thing it's going to do is it's going to require the person trying to overcome the presumption to do so with clear and convincing evidence, not preponderance. This is the only constitutional right I know about that can be overcome with a preponderance standard. It's the only one. Every other one is required to be overcome with clear and convincing evidence. How Texas got so far off track on this, I have no idea. I've researched, I can't find it. But this presumption is now being codified in the law, which we should do, because it is the law whether we codify it or not.
Questions? All right, thank you, Mr. Pickle. We have Stuart McMullen.
Hello, my name is Stuart McMullen. I'm with Americans for Parental Equality. I'm testifying for Senate Bill 816. We're talking a lot about Troxel v. Granville, and it was just pointed out that this ruling did four major things. One was that it set the following precedents: that parents are presumed to be fit. Parents are presumed to act in the best interest of the child. Parents can only be found unfit with clear and convincing evidence. And that the Due Process Clause of the 14th Amendment protects the fundamental right of parents to make decisions concerning the care, custody, and control of their children. In my testimony, I've listed out several Supreme Court cases over the past 100 years that set that precedent and back it up. In this proposed Bill 816, I do recommend a couple of changes, and they're outlined in this testimony that I've handed out to you. In the temporary order section, it should be changed to read that the court orders equal possession, equal access, and equal rights to both fit parents, or the order is an agreement between parents who are fit parents. In the same section, the same changes in the final order section should be the court orders equal possession, equal access, and equal rights to both fit parents, or the order is an agreement between parents who are both fit. The current Texas Family Code is unconstitutional, and this is why. The state routinely infringes upon the fundamental right of parents to make decisions concerning the care, custody, and control of their children without first alleging them to be unfit and then also finding them to be unfit with clear and convincing evidence. Instead, the state uses the judge to determine the best interest of the child, with a preponderance of evidence, both which violate the due process clause of the 14th Amendment. Senate Bill 816 with these suggested changes will bring constitutional clarity to the family code. It'll put parents' rights above states' rights, and it will also offer proper due process to all fit parents.
Any questions? No? Okay, thank you, Mr. Newman. Judy Powell?
Hello, my name is Judy Powell, and I'm with Parent Guidance Center, and Senator Campbell is my representative, so thank you, Senator Campbell, as a constituent for bringing this bill. We are in support of this bill. Parent Guidance Center helps parents involved with CPS, and so we feel like this is not actually a CPS bill. We feel like under CPS, it's pretty clear when you remove a child that you should already have your evidence for removal, and so we do have some level of unfitness, so judges, I think, could easily overcome any kind of best interest. When you look at the quick factors list on the Holly factors, it's easily overridden in any kind of CPS case. What we do see this happening in the kinds of cases is divorce cases. We had actually a case where the ex-husband kept trying to use CPS, actually, and you see this in a lot of cases. They will keep making calls, and it happens on both sides. It's not just, both kinds of parents will do that. But CPS will come in, investigate, and lo and behold, there's no abuse. So they've done their, due diligence. The children are not being abused, and so the people will end up in court. And so we feel like this bill will help, first of all, get those accusations off the table. You don't get to keep saying that they're abusing the kids or, drug abuse and all this, because CPS will have already investigated that and closed the case. I had a case like that. And so a good judge will say, nope, not going to hear about that because I trust the CPS system did their due diligence. The second thing I want to point out is I actually think that you will have less parents in court when both parties know that if I'm going to make these accusations of unfitness or whatever against a parent, I actually have to have some evidence. It can't be he said, she said. So you're actually giving a tool to the judge where they can say, all right, guys, stop the lies and whatever. You're both fit. Now let's back up and look at those best interests. What is the best for your children? And they can do that, and they can help those people actually, not able to do it through mediation, obviously, if they're in court, to do that. The third thing I wanted to point out is that if anybody's reading Section 1 of the bill, let's see, Section 1, number 2, the court determines, so the court has the ability to override through, the court determines that failing to render the temporary order will cause significant impairment to the child's physical health or emotional well-being. Judges have this tool right here. It's very broad. No matter what, if we've got fitness, unfitness, one parent saying they want whatever, if a judge still at the end of the day says, you know what, I think what this fit parent says is still going to cause significant harm, they have the tool right here in the bill that says they can make that decision for the child in their best interest. Thank you.
Mr. Newman?
Chairman, members, my name is Jeremy Newman. I'm the Policy Director with the Texas Homeschool Coalition. We brought this bill to Senator Campbell because, in our experience at least, a lot of times courts and practitioners don't really understand what Troxel already requires of them. And I really want to try and set the context for this discussion because I feel like we've been talking about this as if we have to debate the policy merits of whether or not Texas should start doing this. Whereas if we're not doing this, we are already breaking the law, because constitutional case law requires what this bill says. And so whether or not this is a good idea, bad idea, isn't really the context of this discussion because the Constitution requires it to happen. What we're saying is you put it clearly into the statute so that the judges and the practitioners can tell clearly what is required of them. And to sort of set the context for this, I want to read this quote from the Troxel decision. It says, "The liberty interest at issue in this case, the interest of parents in the care, custody, and control of their children, is perhaps the oldest of the fundamental liberty interests recognized by this court." I think what we have to realize here is that what we're talking about is who gets to make the initial decision about what is in the best interest of the child. Not who makes the final decision, The court is making that final decision, but who makes the initial decision? So the idea of best interests of the child and the rights of the parents are not in conflict, because in fact, the Supreme Court says the way you determine best interests of the child at the outset is by what the fit parent tells you. And so one of the things that the court said in Troxel is that the courts do not have the authority to substitute their opinion of best interest for that of the parent. You must overcome the presumption in order to overrule the fit parent. And I was going to point out, as Judy already did, that the bill does provide that the presumption can be overcome by a finding of a significant impairment. So it's not like this all or nothing situation where either the fit parent is fit and they get everything they want, or they're unfit and they get nothing they want.
Thank you. Does anyone have any follow-up questions? Okay, thank you very much for being here, and thanks for your input, clarifying some issues for us.